We've all been there, right? Walking down the street minding our own business when suddenly flashing blue lights. A police officer asks to search you. This is the reality of stop and search, a police power that's been a hot topic for years. On the one hand, it's a vital tool for keeping our streets safe, helping the police get drugs and weapons off the streets. On the other hand, it raises serious concerns about our fundamental rights and freedoms. We've got to ask ourselves, are these powers always used fairly and proportionately, or are they sometimes used in a way that's discriminatory and unjust? We're going to delve into the heart of stop and search, examining the arguments for and against, the impact on communities, and the crucial role of the law in ensuring a fair balance between keeping us safe and protecting our liberties. Let's rewind to 1984. The Police and Criminal Evidence Act, or PACE for short, became law. This landmark piece of legislation set out the framework for how the police can use stop and search powers. Before PACE, things were a bit murky, shall we say. There were concerns about police overreach, with people being stopped and searched without good reason. PACE aimed to change that. It introduced the crucial principle of reasonable suspicion. This means that a police officer can't just stop and search anyone they fancy. They need to have objective grounds to suspect that the person is carrying something illegal, like drugs, weapons, stolen goods, or something that could be used to commit a crime. PACE also introduced important safeguards to protect individuals' rights. For example, officers have to identify themselves, explain the reason for the stop and search, and document the entire encounter. This helps to ensure transparency and accountability, making sure that the police are using their powers responsibly. Despite its good intentions, PACE hasn't been without its critics. Some argue that the reasonable suspicion threshold is too low and open to interpretation, potentially leading to biased decisions. Fast forward to 2022, and the political landscape changed again. The Police, Crime, Sentencing and Courts Act came into force, shaking things up in a big way. This act introduced a controversial new power suspicionless searches under serious violence reduction orders, or SVROs as they're known. SVROs allow police to search individuals without any grounds for suspicion. These orders can be imposed on people who have been convicted of certain serious violent offences in the past, even if they've served their sentence. The idea is to deter reoffending and keep communities safe. The introduction of suspicionless searches has ignited fierce debate. On one side, we have those who argue that SVROs are a necessary tool to tackle serious violence. They say it gives the police the power to intervene before a crime is committed, potentially saving lives. But hold on a minute. On the other side, we have campaigners and human rights groups who are deeply concerned about the erosion of our civil liberties. They argue that SVROs give the police too much power, allowing them to stop and search people without any real justification. This, they say, opens the door to discrimination and harassment, particularly targeting already marginalized communities. The debate surrounding serious violence reduction orders boils down to a fundamental question. How do we strike the right balance between security and freedom? Those in favor of SVROs argue that they are essential for public safety. They point to the devastating impact of knife crime and other forms of serious violence. They say that if these orders can prevent even one life from being lost, then they are worth it. However, opponents of SVROs are worried. They argue that these orders are a slippery slope towards a more authoritarian state. Ultimately, it's up to society as a whole to decide how much power we are willing to give up in the name of security. When it comes to stop and search, it's not just about domestic law. International human rights law also comes into play. The granddaddy of them all is the European Convention on Human Rights, and it has a lot to say about the balance between security and freedom. Two articles in the ECHR are particularly relevant to stop and search. Article 8, which guarantees the right to respect for private and family life, and Article 14, which prohibits discrimination. These articles act as safeguards, making sure that any interference with our rights by the state is justified and proportionate. The European Court of Human Rights has previously ruled that suspicionless stop and search powers can be compatible with the ECHR, but only under very specific circumstances. Now, we need to talk about the elephant in the room race, because when it comes to stop and search, there's a deeply troubling pattern that can't be ignored. Black people in England and Wales are disproportionately targeted by stop and search. Statistics paint a stark picture. According to government figures, black people are up to 7 times more likely to be stopped and searched than white people. That's right, 7 times. And when it comes to suspicionless searches under SVROs, there are concerns that these disparities could be even wider. This racial disparity raises serious questions about whether stop and search powers are being used fairly and without discrimination. Campaigners argue that these figures are evidence of institutional racism within the police force. The police, on the other hand, argue that the disparities reflect higher crime rates in certain communities. However, this argument ignores the complex social and economic factors that contribute to crime and fails to explain why black people are stopped and searched at such disproportionate rates, even in areas with low crime rates. This issue of racial disparity is a major stain on the justice system. It's clear that more needs to be done to address this issue and ensure that stop and search powers are used fairly and equitably. The legality of stop and search powers, particularly suspicionless searches, has been challenged time and again in the courts. Judges have had to grapple with the tricky balance between crime prevention and individual rights. One landmark case that sent shockwaves through the system was Gillen and Quinton versus UK. This case went all the way to the European Court of Human Rights, which ruled that suspicionless searches under terrorism legislation violated the right to privacy. The court emphasized the need for adequate safeguards to prevent arbitrary use of these powers. In another significant case, R. Miranda versus Secretary of State for the Home Department, the Court of Appeal stressed that even when suspicionless searches are permitted, they must be proportionate and justified. The court made it clear that the police can't just stop and search anyone they want willy-nilly. These cases demonstrate that the courts take their role as guardians of our fundamental rights very seriously. They've shown that they are not afraid to hold the police accountable and strike down laws or practices that go too far. The judiciary plays a vital role in ensuring that stop and search powers are used in a way that respects our freedoms. Their decisions will shape the future of policing in England and Wales and will determine how we balance the need for security with the protection of our individual liberties.